Every day in the USA, people find themselves in court.
Yeah, I guess I gotta pee. Wasn't bad.
Mr. McFarland?
I gotta pee, Mom.
Well, hold on. No, we
I
have
gotta pee. I gotta pee.
Mr.
I
McFarland.
gotta piss now. I got gas in my lung, my kidney. I gotta pee. I gotta pee. You want to pee on myself? I gotta pee. To take a bath, I gotta pee.
Is there a bathroom back there?
Yes.
All right, let him use the bathroom and then we'll handle this matter.
Hey, not saying it.
Okay, I'm gonna have it. Yep, you guys can just be by me and see it all over the phone in there, please. Just because there's stuff over there. All right, McFarland,
Yeah,
over there, sir.
I'll speak to Shadow once again. Yeah, I can't laugh.
Sure did. All right,
He's fucking with me again about falsifying charges on me.
sir. We are in court.
Yeah,
You are not going to be swearing on the record.
my man.
Am I clear on that?
Yeah, clear that.
Okay, remove your hood. We're in court. Thank you. We are on the record in the matter of the city of Wyandotte versus Tyrone McFarland, 251228 and 251025. And Mr. Serrano, your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P33828. Today, Your Honor, I appear as MDC counsel for arraignment purposes only on behalf with my client presently in custody. And Your Honor, today I've had the opportunity to speak to him regarding the nature of the charges, all maximum penalties involved. He understands them. Also, he's been explained his advice of rights. I believe he understands those as well. Today, we waive formal reading as well as charges.
Stop.
Excuse
Excuse me. You'll have stop. You will have an opportunity to speak in a moment. We have a recording. It can only pick up one person at a time, so do not interrupt, please. Okay?
Oh, God.
We are waiving formal reading, standing mute, as for a plea of not guilty to be entered, Your Honor.
I'm not guilty.
Yes. So, sir, for the record, your name, please.
Tyrone for
All right.
Mr. Tyrone for.
All right. The court is going to waive the formal reading. Enter a plea of not guilty on your behalf on both matters. The court will note that Mr. McFarland had a pending matter for trespassing and fraudulent schemes and disguises from the date of that offense of July 11th. That was originally scheduled for October 8th for an arraignment pretrial. And based upon Mr. McFarland being in custody on the disorderly conduct matter, the court pulled that case that was originally scheduled for October 8th to today's date as well. So that's why both matters are being heard for an adjournment or for arraignment. So we will schedule these matters for pretrial September 3rd at 9:45 a.m.
The water?
Yes, sir.
And, will it be right back here?
Yes, sir.
And, that means I gotta stay in Wyandotte. Because if I leave, I can't make court. And the police keep trying to put me out of Wyandotte.
Well, counsel,
Tell some, but tell some, you know.
so go ahead. Counsel, as to bond.
Your Honor, my client tells me he's not on probation or parole, has nothing pending, according to what he tells me. He's not working. This family supports four children.
So what did I tell you? Excuse me, what did I tell you about interrupting?
Oh, bad.
Please continue.
You got a garbage can. That's why I eat there. I had a garbage can.
I'm sorry?
You got a garbage can.
Sir, please don't interrupt. Let your attorney
Oh, you're my bad.
make the record. Thank you.
He does support four minor children, Your Honor. He tells me he's not working, nothing pending. He tells me he's never failed to appear in court before, but the court has the records in front of it, so I'll leave it in the court's discretion. These are not serious charges, Your Honor, but I think he has a failure to appear in court in the past, but we leave it in the court's discretion, either a personal bond or a bond he expect to post. Thank you.
I can't afford no bond. I can't afford it now. I can't afford a bond. I got a bond. I do a constant bond.
Okay. I don't know all my buying conditions she's not that worked here. Before I lost my hand hurts. All right. Well, sir, let me see here. I know you've been here a number of times.
I think you need one judge.
What's that?
It's probation.
All right, thank you. I need actually two of them, but I think that actually they don't have it. I think Angela has them on her computer. Okay, so I believe, sir, you were recently in custody, and then
What about all time? But no.
Sir,
All time?
yes, please let me talk.
And you did
Let me talk.
do it again.
Let me speak. I need to make a record. And then, and I believe that Mr. Lloyd represented you, and you were deemed not competent and not restorable. And the prosecutor at that time had chosen not to petition the probate court for guardianship based upon the determination that you were not confident and not restorable. And so then you were released from custody. And then it appears on July 10th of 25 that you picked up a matter in River Rouge. And then July 11th, then you picked up 2 counts in Wyandotte. So, what happened in the matter in River Rouge? Do you have a pending court date?
Yeah. That was good, but it really put me in the hospital. It really put me in the hospital. Something wrong one day. Put me in we did one comfort hospital. Something wrong one day. That was their fault. Yeah, what was it? They called me one hospital. They came out and go and them come out and did one. Shake your phone. They been around and to be all up. Would feed me, be all up stuff. They played. Be all I couldn't go nowhere. Could go to bed and be watching me. I tried to talk to somebody. I couldn't talk to nobody.
Okay, now,
Yeah, nobody. Why you like that?
that was while you were in the hospital?
Mm-hmm. Yeah, very. You know, he took my face.
All right, sir, you reside, who do you reside with in Detroit?
Mm-hmm.
It says it has your address on East Jefferson in Detroit.
Say what?
The address we have for you.
I live in Detroit. I had that in Detroit. Except for the streets everywhere. I don't want to speak. My home was in street 0. My address 000. 6 times.
Okay. All right. Well, here's what the court's going to.
And I want a place to sit. And I
Want a
want
place to sit? Is that what you said?
I want a place.
You don't want a place to
No.
sit? Okay.
Here's the doctor. You might say the doctor. That you are. You can't take your medicine, keep you on, The one with the E-ball in the world. Not get the E-ball. We all change very often. Yes, we got to speak something like
Well, it shows that you're ordered to have a tether. Is it 25th District Court ordered a tether?
I want no goddamn jail. Put no goddamn jail because the fuck that's misdemeanor.
Excuse me,
Put no jail for no goddamn misdemeanor.
sir.
Put
As I stated before, we are in court. You're not going to be swearing on record.
what you want? We gonna put your teller on here. I gotta go to county jail, put the teller on.
Sir, did you hear my question? My question was whether or not you were ordered to have a tether from the 25th District Court. That's
No. You know what? The only time I had to tell her, you said I'm gonna take girls blood in the back of my hand. You put a teller again. Well, July 7 of 2025.
July 7th.
Yeah.
They ordered a tether for you.
Yeah, from July 7 all the way till May 10 of 2024, 2025, May 10 and the teller.
Okay. All right. Well, here's what I'm going to do. Given that Mr. McFarland was in custody previously and deemed to be not incompetent and not restorable, and due to the prosecutor's failure to petition for Mr. McFarland to get treatment that he
He leaves. I'm not man to heal. I'll physically say what not meant to say. I'll physically say what not meant to say. So that ain't talking about me anything. That's what you said. That's what I can tell.
Sir. That
Yeah.
was based on the opinion.
The proof already called
That's
it.
like-
Proof already called it. I articulate well.
That's fine, but you're also articulating well by trying to speak. So, based upon Mr. McFarland, not having any stable housing, whether
I want to stay, Doc. I want to stay.
000
I'm set up a plantation. Do you set up a plantation?
no,
I want to stay. I want to stay.
sir.
The state wants me for everything I do, but they don't do it.
I will give you an opportunity to speak in just a moment. Given defendants prior criminal matters, the pending matters, thank you, that he currently has in this court, and now he has this matter that he was arrested for last night. And it also shows
He's bad for me.
you're gonna have to wait, sir.
I gotta hope I can cancel me. I can cancel the kids. Oh, I can't have my body. I gotta piss. I gotta piss, you guys. I gotta piss. I'm pissing myself. I gotta piss.
Sir,
I gotta piss now.
I
I'm
just,
gonna get a piss now. Fuck, I piss my goddamn self. That's the other damn case.
sir, you
What?
you just used the
I gotta eat grab. I gotta piss. I'm pissing 90 times a minute. I got cancel. I got cancel. Gotta go piss.
Okay, great. You can go to the bathroom.
Thank you.
$7,000 on each matter, not to be you can do tentative treatment, otherwise you're not to be released without time.
Thank you, Your Honor.
Thank you. State of Michigan versus Mitchell Meyers, 251225. And detective, you are need for the record, please.
Detective Chelsea Hack, NY. Police Permit.
All right, please raise your right hand. You solemnly swear affirm testimony not to give this matter the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. You may proceed on the warrant.
On August 20th, 2025, at 20:51 hours, Wyandotte officers were dispatched to a weapons call at 525 St. John's in the city of Wyandotte. Dispatch advised the officers that William Meyers stated his son, Mitchell Meyers, was upstairs in his bedroom threatening his mother, Sherry Meyers, with a gun. William stated Mitchell and Sherry were fighting over the gun. Officers arrived on scene and observed William to be outside, stating his wife Sherry was still inside. Shortly after, Sherry exited the house, stating, "Please help me," and that Mitchell had a gun. Officers continued announcing police presence to exit the home. Officer Heltzman observed Mitchell walk through the home with a handgun in his left hand. Mitchell then went out of officers' sight. Officers heard numerous loud noises from inside the home. At 21:02 hours, Mitchell exited the home with his hands in the air. Mitchell was arrested by officers. No firearm was recovered on Mitchell. On scene, Sherry stated Mitchell suffers from diagnosed bipolar disorder, and the family believes that he has schizophrenia and that he has been extremely paranoid recently. Sherry stated that Mitchell was claiming William took firearm ammunition from a locked safe and was selling it. Sherry explained to Mitchell that William would not do this, which started a verbal argument. Sherry stated Mitchell claims he is the only one that can protect the home. Sherry stated she was looking for ammunition in Mitchell's bedroom when she saw numerous firearm magazines on the floor. Sherry retrieved these magazines and also located a loaded Luger handgun on the floor, which she secured into her purse. Sherry then confronted Mitchell about this, who was sitting on the bed. Sherry then observed Mitchell to be dealing another firearm in what she described to be shiny underneath his buttocks. Sherry then asked Mitchell numerous times why he had the firearm and to give it to her. Sherry then described the altercation to be physical when she was trying to take the firearm. Sherry stated Mitchell claimed he would harm himself at that time. Mitchell also claimed he would assault William if he came upstairs. During this altercation, Sherry had her daughter, Miranda Meyers, on the phone. During the altercation, Sherry had her daughter, Miranda Meyers, on the phone. Miranda stated that she believed Mitchell was going to shoot Sherry while hearing the altercation. On scene, William stated he was in the basement on the phone with dispatch while this altercation occurred. William stated he believes Mitchell wants to kill him. William stated there were 4 firearms inside of the home. The Meyers expressed concern that Mitchell was high or intoxicated due to drinking and abusing his prescription medications. I was advised Mitchell had a VAC of 0.054 during booking. During his arrest and booking, Mitchell made statements about discharging the firearm inside of the home into Williams' computer. Mitchell had 19 .22 caliber bullets on him in the rear compartment of a fanny pack, which was collected during booking. A search warrant was executed on the home. Officers seized 4 handguns. During the search of the home, it was confirmed Mitchell had discharged a 9mm silver Browning handgun into the laptop computer belonging to William. The handgun was located on a table in the basement just outside the room with the laptop. A spent 9mm casing and several partial lead cores and copper jacket fragments were collected from the basement floor. A bullet hole was observed through the laptop keyboard, which traveled through the table and into the cement floor.
Thank you for that examination and defense to the commission of probable cause leading to those offenses. All right, counsel, your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P33828, appearing on behalf with my client, presently in custody. Your Honor, my client would like a formal reading of the complaint, please, of all charges.
Sir, your name for the record, please.
Mitchell Meyers.
All right. The court has before it a complaint that alleges on August 20th of 2025 in the city of Wyandotte that you did intentionally discharge a firearm in a facility that you knew had reason to believe was a dwelling or a potentially occupied structure in reckless disregard for the safety of another. This is a felony charge. The maximum penalty upon conviction is not more than 10 years in state prison and a $10,000 fine, mandatory forfeiture of the weapon or device. Second count is felony firearm. It's alleged on the same date and location that you did carry or have in your possession a firearm, that being a handgun at the time he committed or attempted to commit a felony. That means that this is a dumping. It's a felony charge. The maximum penalty upon conviction is 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of the weapon and device. Counsel, are you satisfied with reading of the charges?
Yes.
The court for the entrance to the next standing on your behalf, sir, and schedule this matter for probable cause conference on September 4th at 10 a.m. Counsel asks to bond.
Your Honor, my client tells me he's age 30. He lives with his mother and father who support him. He's not working presently. He's not on probation or parole. He tells me he has nothing pending in as to criminal matters. Your Honor, I don't believe he's never appeared in court before or never failed to appear in court before. Seems to be something that's out of character for him. Your Honor, we ask the court to consider a personal bond with some safeties, of course, to the family members and with conditions. If not, a bond he reasonably expect to post. Thank you.
All right, and sir, why don't you work?
When I was in third grade, I was put on the medication and I took it. Well, I dropped it. And I failed 6th grade. And then 13 years after I started taking it. And after I stopped taking it, I don't know how other way to put it. I basically just lost my personality and any drive to do anything, any drive to make friends or talk to people or go out in public. I just recently went back on the medicine. Not sure how long ago that was, like maybe 4 or 5 months ago. I've been looking for work, but they don't want me because I don't have a driver's license and I haven't worked for 10 years.
Okay, so, sir, if you are not permitted to go back to the home, where could you go to stay?
Friend or maybe go to rehab.
Okay. And have you ever failed to appear in court for any reason, sir? Sir? I can't hear you. Have you ever failed to appear in court for any reason?
If you ever feel them.
No.
Patty, would you like to address that?
Yes, Your Honor. I do have serious concerns for the complaining witnesses, their safety in this matter. Obviously, they both expressed that Mitchell has struggled his entire life with mental health issues and that it has been escalating recently. I would just like you to take that into consideration when deciding bond.
Court just has some serious concerns with safety of the complaining witnesses in this matter, as well as Mr. Meyers not really have any stable residency to stay at in the interim, not having any ability to not having any reason that would tie him to the community as he doesn't work as well. The court, based upon the nature of the allegations, the seriousness of the charges, safety of the public and the complaining witnesses, the court's going to order a $50,000 2% bond. You, in the event bond is posted soon, and even in the event that you remain in custody, you're not to have any contact. Mr. Myers, where'd you go?
Oh, I'm sorry. I'm
You're not
right here.
You're not to have any contact with William Myers or Sherry Myers. That's phone contact, text message, email, social media, anything of the like. No third party. You cannot call them from jail. So if there's somebody that you think you're going to call to help with your bond, it's not to be done. You're not to return to the home on St. John's, except with the assistance of a police officer to get us the personal belongings. You're not just specifically alcohol or dogs unless prescribed. You're not to possess or necessity firearms and loading weapons. And you are not to be released on GPS and alcohol until you Lincoln County Jail. Any questions regarding those conditions?
Yeah. Does that mean I'm going to jail?
Do you have $5,000 to pay, sir, or somebody to pay that for
I
you?
wanted to call a bail bondsman.
Okay, you can call a bail out and just have your parents. The court also, sir, I just want to remind you, because I did not tell you previously, you do have a right to have an attorney. If you cannot afford one, you could have one appointed to represent you. The court signed the appointment attorney for felony matters. You also have the right to use your innocence if it goes beyond reasonable doubt. You have the right to have a trial by a judge and by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand all those rights?
Yeah.
Okay. All right, sir. We'll see you back on September 4th. Thank you.
Thank you.
Yeah.
All right, you're off the record.
What was that?
Okay. We'll